Welcome back to the deep dive. If you've ever wondered exactly where the law draws the line between a minor mistake and a major catastrophe, well, today is your day.
It really is.
We're diving into a really high-stakes question in tort law. When a defendant fails in a basic duty, say they don't fix a security system, and that failure is followed by a completely unpredictable, violent criminal act by someone else, does the original defendant still have to pay?
This is, the ultimate test of legal responsibility.
Yeah.
We're talking about proximate cause, which is really the court's way of being a gatekeeper of preventing liability from stretching on forever.
Into infinity, right.
Exactly. The core problem is deciding whether that criminal act is so independent, so unforeseeable that it legally breaks the chain of responsibility. Does it make the original defendant, well, blameless for that final terrible injury?
That sets the tension up perfectly. We've got a roadmap for this, and it's all anchored by the landmark case Medcalf v. Washington Heights Condominium Association. So what's the precise analytical path we need to take to solve this?
We have to be really systematic here. First, we need to quickly go over the foundation of any negligence claim, but we'll focus specifically on legal cause.
Right.
Second, we'll dissect the two components of legal cause. There's a causation, in fact, and then the much trickier one, proximate cause.
And finally,
we apply the critical doctrine of superseding intervening causes. We use the facts in the ruling in Medcalf to really understand how courts draw that line between a foreseeable risk and just random bad luck.
excellent. Let's start with that foundation then. Before we even get to who pays, just give us a quick refresher.
Right.
What are the 4 elements you have to prove to establish a basic negligence case?
So for any negligence claim, a plaintiff has to prove 4 things: duty, a breach of that duty, causation, and finally, damages. And in cases like Medcalf, 99% of the fight happens over causation, or what we call legal cause.
Got it. So if legal cause is the heart of it, let's drill down into its most fundamental piece, causation, in fact. What's the legal test for that initial connection?
Causation, in fact, is the broadest measure. It's the purest physical connection. The standard test is the but-for rule.
The but-for rule.
Right. The question is, would the injury have occurred were it not for the actor's conduct? If the injury would have happened anyway, then the defendant's action wasn't a cause, in fact. It's as simple as that.
But the but-for test can feel, I don't know, almost philosophical, right? It feels way too broad. If I run a red light and hit a bus, the but-for cause could be the day I was born.
All right.
So if that test is too generous, how does the law use proximate cause to rein it in and make it fair?
You've hit on the exact policy reason it exists. Proximate cause is there because courts have to put a reasonable limit on liability. It's a policy decision. In Connecticut, where this case is from, the standard is that the defendant's act must be an actual cause that is a substantial factor in the resulting harm.
A substantial factor, what does that actually mean in practice?
To meet that test, you have to focus on foreseeability. The question is this: was the harm that actually occurred of the same general nature as a foreseeable risk that was created by the defendant's initial negligence? If the harm is wildly outside that scope, the cause is just considered too remote, too far away.
Okay, that brings us right to the heart of the Medcalf case, an intervening criminal act. So the jury found the condo association was negligent. How does the law treat what happens next, the violent attack by a criminal? Does that just automatically cut off the condo's responsibility?
Well, typically, yes. It's the default position. The general rule is that the act of a third person committing an intentional crime is usually a superseding cause of harm.
Why is that?
The law basically sees that intentional criminal as having deliberately taken control of the situation, cutting off the original defendant's chain of liability. But, and this is the crucial exception, a plaintiff can still recover only if the harm from that criminal act was within the scope of risk created by the defendant's conduct.
So the million-dollar question for the condo association is, did our broken intercom make this specific type of criminal attack reasonably foreseeable?
Exactly. It's all about predicting the type of bad outcome. If you leave a dangerous snake enclosure unlocked, the foreseeable risk is a snake bite. If someone then trips over the cage and breaks their arm, well, the snake bite was the risk you created, not the fall.
That sets us up perfectly. Let's dig into the case and model the court's thinking. We are analyzing Medcalf v. Washington Heights Condominium Association, Inc. First, what are the legally dispositive facts?
Okay, so the plaintiff, Michelle Medcalf, gets to her friend's condo around 9 p.m. It's dark, the street lighting is dim. She tries to get in, but the building's electronic buzzer and intercom system doesn't work.
It's broken.
Completely broken. So she's forced to wait outside the locked lobby for a friend to come down to get her. And while she's waiting there, she's attacked and injured by a stranger, a man named Kenneth Strickler. And the key fact here is that the jury found the condo association liable based only on the failure to maintain that intercom.
Wait, so the jury found for the plaintiff? They must have thought it was foreseeable. So how did the appellate court even get involved? What was the core legal issue the defendants raised on appeal?
And this is where that judicial gatekeeping comes in. The precise legal question was whether the failure to maintain that intercom system was the proximate cause of her injuries from the criminal assault. Or was the assault a superseding cause that the jury just couldn't, as a matter of law, say was foreseeable?
What rule of law did the court apply to figure that out? Can you state the full black-letter rule and break it down into its testable elements for us?
Of course. The court applied the rule for legal cause. So the plaintiff had to prove both causation in fact and proximate cause. To decide if the criminal act superseded the defendant's negligence, the court focused on these two elements. 1, causation in fact, the but-for test, and 2, proximate cause, the scope of foreseeable risk.
Thank you. Now for the court's elemental analysis. Let's go through this step by step. How did the court apply that first element, causation, in fact? I mean, did the broken intercom actually cause her to be exposed to the danger?
Well, the sub-issue there was the connection between the system's failure and where the injury happened. And the facts were clear. The intercom failed, so she was forced to wait outside.
So, but for the broken intercom, she wouldn't have been standing right there.
Exactly. The court sort of noted that maybe the injury could have happened anyway, but they pretty much granted that the failure forced her into that specific location. It satisfied the technical but-for test. But, and this is important, they found this element was ultimately inconsequential when they moved on to the next one.
Understood. So the whole case really pivots on the crucial second element, proximate cause, and that idea of foreseeable risk. What was the court's analysis on that point?
The sub-issue was this. Was a violent, intentional criminal assault by a stranger within the scope of foreseeable risk created by a broken entry buzzer? And the court came down with a hard no.
And their reasoning?
In their application of the facts, the court said, look, the foreseeable risk of a malfunctioning intercom is, at most, being inconvenienced. Maybe you get delayed. Maybe you get your finger caught in a door.
Right, minor stuff.
Minor stuff. The plaintiff didn't offer any evidence that the intercom was designed to provide security to people outside the building. So the court concluded that the defendants could not have reasonably foreseen that a broken buzzer would become the substantial factor or an inducement for a violent criminal assault by one stranger on another.
So the court is essentially saying the type of risk the negligence created, a broken buzzer, it just didn't match the actual harm that occurred, which is a random violent crime.
Precisely. The court needed to see evidence that the condo's negligence created a specific, substantial incentive for that type of harm. You know, if you fail to fix a light bulb outside a known drug den, maybe a mugging becomes foreseeable. But failing to fix a buzzer with no history of similar crimes just doesn't make a violent assault foreseeable.
So after walking through all those elements, what was the court's final conclusion? Why did they overturn the jury?
The judgment was reversed. The court ruled, as a matter of law, that the jury could not have reasonably found the assault was within the foreseeable scope of risk. Because the harm wasn't foreseeable, the plaintiff failed to establish proximate cause. Strickler's intentional criminal act was therefore deemed a superseding cause. The condo's negligence was just too remote.
Okay, to really cement this difficult idea, the difference between a but-for cause and a legal cause, let's use a really visceral non-security hypothetical. Let's say a negligent restaurant worker fails to clean a huge spill. A patron slips, falls, breaks a leg. That seems like clear liability.
Absolutely, textbook slip and fall.
But now imagine that same patron is lying injured on the floor and a totally different stranger, no connection to anyone, deliberately and maliciously runs up and kicks the injured person before an employee can get there.
That's a perfect test of the Medcalf rule. The negligent spill caused the fall and the broken leg. That's both causation, in fact, and proximate cause.
Yeah.
The foreseeable risk of a spill is someone falling. But that malicious kick afterwards is an intervening, intentional criminal act. So we have to ask the question, was the injury from that kick within the foreseeable scope of risk created by spilling the water?
And the answer has to be no. Spilling water doesn't make a random criminal assault foreseeable. It doesn't induce it.
Absolutely not. The kick is a superseding cause. All responsibility for the additional injuries from that kick shifts to the third party who did it. The restaurant is still on the hook for the original broken leg, but its liability stops where that superseding criminal act begins. The law demands a logical connection.
That is incredibly clarifying. Okay, let's translate this whole deep dive into an actionable tool. For our listener who needs to spot this issue on an exam or analyze a scenario involving a third-party crime, how do they systematically break down the problem?
You really need a 4-step diagnostic checklist. You have to go in the right order.
Okay, what's step one?
Step 1. The foundation. You have to establish the underlying negligence first. Did the defendant have a duty and did they breach it? If the answer is no, you stop right there. If yes, you move on to legal cause.
Step two?
Step 2. Causation, in fact.
Yeah.
Apply the but-for test. Was the defendant's conduct actually necessary for the injury to happen? If the injury would have happened in the exact same way regardless of the breach, liability ends.
Okay, makes sense. What's step three?
Step 3. Proximate cause. This is the big policy gatekeeper you have to ask. Was the harm that occurred of the same general nature as the foreseeable risk created by the breach? If the foreseeable risk of a broken intercom was just inconvenience, but the actual harm was a violent assault, it's too remote. Liability ends.
And the final step for cases like Medcalf.
Step 4. The intervening act. If you have an intervening intentional or criminal act, you apply the superseding cause rule. You treat it as a chain breaker, unless the original negligence made that specific intentional harm highly foreseeable, like failing to lock a bank vault. But if the failed intercom didn't induce the specific assault, the liability chain is severed. The original defendant is off the hook.
That is a masterclass in legal analysis. The key takeaway then, going back to where we started, is that not all causes are legal causes. Even if a defendant's action is technically necessary for an injury to happen, the but-for cause, the chain is strictly limited by this principle of foreseeability. The law makes sure liability actually matches the scope of the risk created.
Indeed. And Medcalf really shows that it's extremely difficult to hold someone responsible for protecting against third-party criminal acts without a very high degree of specific prior knowledge of that risk. Which leads to a final thought for you to consider. What if the plaintiff in Medcalf had shown evidence of numerous documented violent assaults in that lobby that the condo association knew about and ignored? Would that specific knowledge have been enough to make the failed intercom the substantial factor for proximate cause?
A question that completely changes the risk profile. Thank you for guiding us through this challenging deep dive.
My pleasure.
We'll catch you on the next deep dive.